Morning and welcome to the webinar. My name is Phillip Kruger and I'm a director in the legal department of RSM South Africa, based here in Johannesburg. Our session today will focus on data privacy and particularly on what we know now, after a number of years have passed since the advent of data privacy globally, as well as our very own data privacy legislation locally. Looking at what our agenda will be today, we're going to start with a general background as to the data privacy landscape and what has been implemented since POPIA's commencement date. Then we'll have a look at the very well publicized Ashley Madison scandal and what occurred in the aftermath of that scandal. We will also have a look at cybercrime and what our observations have been around external breaches. Then we will make some general recommendations as to how to deal with data breaches when they occur. And then lastly, we'll provide some final thoughts on the matter as a whole. Now, starting with the general background, South Africa had significant debate around whether or not data privacy should be legislated within South Africa or not. Be that as it may, though, on 1 July 2020, POPIA finally commenced, whilst allowing for a one-year period for both public and private entities to comply with its provisions. This one-year period then came to an end on 30 June 2021, and we are now almost 3 years into full-blown POPIA compliance. The general intention of POPIA is to promote the protection of personal information processed by public and private bodies, and I would submit that POPIA has been fairly successful in doing this. These days, it's really common to see and complete consent forms before an organization would take possession or start processing your personal information. And we at RSM have also seen a number of South African business groups adopt rather robust policies in terms of POPIA, as well as the GDPR and other offshore data privacy requirements, mostly depending on where the group companies or the headquarter companies lie. Where we do think businesses are still facing some challenges is in the implementation of these policies. But on the whole, I think the foundation for higher standards of protection of personal information has certainly been created. Secondly, POPIA is also aimed at establishing 8 data processing principles. Now, these are very similar to the data processing principles that are found in terms of the GDPR. And again, even though we might not see strict adherence to all 8, we have certainly seen that most commercial businesses have, to differing degrees, attempted to be more aware of how, when, and why they are collecting personal information about their customers, employees, and stakeholders. Now, the third intended objective of POPIA was the creation and establishment of an information regulator to oversee POPIA compliance and its enforcement. And this is where we see so many well-intentioned pieces of legislation in South Africa fall flat. Implementation and enforcement has become one of South Africa's biggest challenges when it comes to legislative requirements. One only really needs to look at the recent developments around e-tolls and to realize that legislation is really only worth as much as the enforcement of the rules behind that legislation. It's in this regard that I'm glad to report that despite initial fears to the contrary, the information regulator has indeed delivered. The regulator has a very well-constituted leadership and executive teams. We can see on the slide there that Advocate Panzi Plakula is still the chairperson of the information regulator, and she has indeed been involved since the get-go. She has with her now 2 other full-time members, as well as 2 part-time members, and they take up the leadership role within the information regulator. They are then further supported by a full staff component, and that staff component is headed up by a appointed CEO, 4 executive employees, as well as a CFO. So as you can see, all the elements are there for a proper functioning and operating regulator. In terms of dealing with data breaches, the regulator has indeed decisively dealt with a number of high-profile breaches. This would include the TransUnion data breach, where a ransom of 223 million rand was demanded for over 4 terabytes of compromised data. Now, if you're wondering how much 4 terabytes of compromised data would be, it would be the electronic equivalent of indeed a truckload. There was also the more recent CIPSI data breach, where the Companies and Intellectual Property Commission was indeed breached with some sensitive information and indeed personal information being accessed by unauthorized individuals. There was also the Lockbit breach, where 668 gigabyte of data was extracted from the South Africa Pension Agency, and various other breaches taking place within the private sector in the South African landscape. Similarly, the information regulator has delivered in respect of taking public action against direct marketing transgressions, with a number of civil claims being instituted both on the basis of POPIA as well as the Promotion of Access to Information Act. One of the recent cases that's going to be interesting to watch in respect of PIA compliance is the Google matter. Recently, our large media houses are taking Google South Africa on in respect of access to the proof in respect of their return submission to SARS. The media houses, of course, having to prove then that they have an interest in seeing proof of those returns being submitted. So that's certainly one that I think is going to be interesting to see, both from a POPIA application as well as a PIA application. Now, the aforementioned all provides a very positive outlook in respect of the implementation and the processes of the enforcement-driven side of POPIA. And don't get me wrong, that's a big positive. That's a big win that we should celebrate. However, despite all the good work, the information regulator has gone on record to say that they are receiving more than 150 breach notifications per month. That's monthly, not annually. And indeed, that is a scary figure. Therefore, it seems to imply that cyber criminals have found very fertile ground in South Africa, with the most prominent failure then being the fact that businesses are struggling to address data breaches appropriately. Data from Kaspersky has shown that 82% of surveyed South African companies said they faced cyber incidents in different forms. And interestingly enough, 11% of those were caused by deliberate malicious behavior by employees. Again, quite an interesting statistic there. Now, having seen how prevalent data breaches in South Africa is, let's look at the so-called Ashley Madison scandal and the aftermath in respect of the scandal. Now, this is one of the juiciest and certainly most well-publicized data breaches, which occurred during 2015. And at the time, all of us working in the industry were really watching on the edge of our seats to see exactly how the incident will be handled, both by the executives within Ashley Madison as well as the relevant authorities. Now, for those of you that are not aware of the facts of the incident, the basics are as follows. It was the personal details of 37 million members of the Ashley Madison site that was exposed online. Now, the Ashley Madison website is used by men and women to have affairs. Importantly, it caters for married men and married women. So it's essentially a dating site to have extramarital affairs. Now, why is this important from a South African perspective? Well, the 37 million included the details of 175,000 South African men and women who used the site. Now, if you are interested, and in truth, if you are brave enough to want to see more in respect of the Ashley Madison scandal, Netflix currently has a very good documentary on the Ashley Madison scandal, which, even if it is a bit racy, is still very well worth watching. So how did Ashley Madison's management deal with the data breach? Well, in one word, horribly. By their own admission, they were simply not prepared for an incident such as a data breach. The executives who were with the company at the time have summed it up by saying data security was something they spoke about. Yes, it's something that concerned them, but it was not something they lived. It was not something they thought about every day. Now, this is strange, particularly given the sensitive nature of the information held by them. But it's true, and at the time, data privacy was not as front of mind as it is today. So Ashley Madison's executives then took the initial decision not to involve law enforcement, at least not until the scandal was made public. Now, this, in my view, was a cardinal mistake. It hampered not only their own investigation, but it tainted their entire executive management with a brush that screamed cover up. They did appoint two experts from Sweden, hoping that they could investigate and somehow make this problem disappear. What is notable and interesting is that they didn't engage with their customers whatsoever. In short, one gets the feeling that they hoped that they could close their eyes, quickly find their data, and move on with life. They also tried to make contact with the suspected hacker to attempt to negotiate a settlement price in order to have their data handed over to them. However, this failed quite spectacularly in the sense that the identified suspect merely said, "It wasn't me." So, how did all of this play out for Ashley Madison? Well, in two words this time, very badly. The data breach could not be contained as they had hoped. Their customers' most personal information was published. This means that the customers' names, their reputation, their relationships, and often their livelihoods were completely destroyed. To add insult to injury, after the initial data dump featuring everybody's names, the hackers attended to a second data dump, publishing the credit card details and even in some instances, nude photographs of the customers of Ashley Madison. And in truth, only the American lawyers came out on top, with a myriad of legal claims, divorces, civil liability disputes and cases, all being instituted, argued, and ultimately settled at astronomical costs. So where is Ashley Madison today? Well, interestingly enough, their membership has more than doubled to 85 million members. This, however, I would submit speaks more towards some of humanity's propensity to infidelity than to the faith and trust that they put within Ashley Madison's cybersecurity systems. Ultimately, the company did suffer massive damages. It took an incredible hit in terms of reputation. And in truth, the company had to rehaul its executive management in order to continue its business. Simply put, the key executives that were there at the time, pre-breach, were no longer there post-breach. So ultimately, this really hurt Ashley Madison. Now, if we then have witnessed this Ashley Madison scandal, as well as the myriad of data breaches thereafter, what, if anything, have we become wiser? Well, the first thing is that data breaches are not reserved solely for the likes of the Ashley Madisons of the world. There are a great number of so-called ethical and moral purists who hold the view that somehow Ashley Madison deserved to be hacked due to the nature of the service that they rendered. However, there is simply no basis for such an assumption. Ashley Madison simply fell victim to an unscrupulous cybercriminal who had no right to invade other people's privacy in the way that they did. More so, subsequent cyber attacks have shown that cybercriminals do not discriminate on the basis of values, ethics, size, or financial means of a company. Where they see a vulnerability, they will exploit it. This becomes even more evident if one considers the statistic that cyber criminals, on average during 2023, received 17.9 million rand from South African companies in the payment of ransoms. The cost of remedying the attacks, excluding the ransom paid, was on average determined to be between 19.4 million rand and 40 million rand. Now that is astronomical figures. This is according to an article published by Network 24 on 2 May 2024, if you are interested to read a little bit further on that. But what this figure does make abundantly clear is that hackers are not the reclusive people that we often think they are, sitting in their parents' basements. Cyber criminals operate as sophisticated crime syndicates, and they exercise data breaches that are methodical, well-planned, executed by what one could almost liken to be professional staff. Before electing a target, they consider the information at hand. They look at personal information sensitivity, what the quality of that personal information is, what the potential profit or loss could be. They look at price, and they certainly look at supply and demand factors in respect of calculating the ransom that they would ask. They also generally tend to be one step ahead of your general cybersecurity requirements and systems. They often breach your system for months before you even realize they have breached. They explore during that time your systems and data vulnerabilities, and they determine whether your information is of sensitive enough nature and holds enough quality to the information for them to receive any value from initiating a ransom attack. And as mentioned, it's all about the money. It's very likely that personal information will typically be held for ransom. In other words, the cyber criminals will demand that you pay them a significant lump sum of cash in order to avoid publishing the personal information of your customers, your clients, your employees, and your stakeholders. Usually, this information is stored on the so-called dark web, on secure locations, or the so-called dark web leak sites. Failure to make payment will then result in the personal information of your clients, customers, employees, and stakeholders being released and leaked for all to see. Now, knowing what we know now about data breaches and the likelihood of data breaches occurring, to me, it puts the provisions of POPIA in a completely different light. With the commencement of POPIA, it seemed to many to be just one more set of compliance rules, one more way for consultants to make money. But if you really think about it, POPIA is designed to protect the data subject, yes, but it also mitigates your potential damages in the event of a breach if you comply with the 8 basic principles for lawful processing of information. Just very quickly, those principles would be the first being accountability. So in other words, who is accountable, which in POPIA terms is always the responsible party. Second one would be processing limitation. You can only process specific sets of information for as long as you need to process it. The third would be purpose specification. You can only process for a specified express specification. Further processing limitation, if you are further going to process or indeed further push information out, that has to be for a specific purpose. Quality of information, your information quality has to be up to date. Openness, you have to be transparent about your policies. Security safeguards, you have to have appropriate and reasonable cybersecurity systems in place. And of course, lastly, data subject participation. Data subjects have to be able to see their data, they have to be able to request their data, and indeed, they have to be able to notify you to stop processing their information. Now, if one thinks about it, POPIA forces you to only have information that you are legally entitled to have, particularly if you look at the consent requirements. So you have to have valid grounds for processing. In a position where a breach takes place, no one could therefore ask the question, why did you have my information, without you having an answer readily available, provided that you implemented the 8 processing principles. Secondly, if one looks at the principle of minimality, it forces you not to have more personal information than you would reasonably need. When we speak about the supply and demand elements when it comes to cyber criminals considering a potential target, it follows that the less personal information you have, the less likely of a target you become. Thirdly, POPIA requires you to destroy or de-identify personal information you don't reasonably require anymore. Again, the more information you retain, the larger your potential liability in the event of a data breach. Lastly, POPIA forces you to notify data subjects and the regulator in the event of a breach. This enables you to warn your customers and clients to be vigilant and potentially mitigate their risk in respect of leaked personal information, and thereby doing, you also mitigate your own potential exposure in terms of liability. So, given the statistics, it is sadly safe to assume that your firm, company, or organization will eventually become the victim of a data breach that's planned and orchestrated by cyber criminals. And that is if you haven't been a victim already. So, in an environment where you are likely to fall victim to such a crime, what can you do? Do you merely sit and wait for D-Day to come? No. Like anything else in life, the best thing you can do is to be prepared. In other words, be proactive. They always say that prevention is better than cure. So how do you prevent a cyber incident? Firstly, you follow the 8 principles for processing as set out in POPIA. Secondly, you adopt and implement policies that will mitigate your risk. You imply cybersecurity systems that are robust, even if they are not always convenient. Various factor authentication points can be a bit of a pain, but they serve a purpose. Provide training to your employees as to potential phishing emails and other scams designed to gain entry to your systems. Make your employees aware so that they can assist you in this battle. And then, of course, our second point there, be aware that a data breach can happen at any time, no matter how preventative you are. Be prepared in how you are going to deal with it. Make sure you determine beforehand who will be on your breach response team to avoid floundering around and looking for individuals who can deal with it appropriately when the time comes. Usually, in respect of a breach response team, you will need a legal professional, a IT risk professional, and someone who knows the inside workings of your business, like the back of the hand, such as a chief operating officer. And importantly, you will also require IT systems and cybersecurity expertise, which will most likely be forthcoming from external experts. So make sure you identify those suppliers before a breach even happens. Importantly, make sure you have backup data. Generally, a cyber attack creates massive losses on 3 levels. One, firstly, potential ransom demands, which is obvious. Secondly, the costs in dealing with a breach, which we have seen are significant. And thirdly, in respect of potential downtime that the business simply cannot operate due to not having access to your own data. By having sufficient backup files, you can mitigate your risk under point 3 and be back up and running as soon as you possibly can. And very, very important, do not make the mistake that Ashley Madison made. Report the data breach to the law enforcement or SAPS immediately. In this regard, I can draw your attention to Section 34 of the Prevention and Combating of Corrupt Activities Act. That makes it a requirement to report certain actual or suspected corruption, theft, fraud, extortion, forgery, and uttering of forged documents involving more than 100,000 Rand. You have to report that. It's a legal obligation. Failure to report it will make you yourself or your executive team guilty of a criminal offense. Then on our next slide here and our next recommendation, request proof of life. It sounds strange requesting proof of life in respect of data files, but it is essential that you establish that the cyber criminals indeed have the actual exfiltrated data and have possession of the files that they claim to have. Otherwise, you can avoid a very costly exercise. And then, of course, you need to notify the regulator and the data subjects as required by POPIA. But surprisingly, it's not always possible to notify immediately, as you may simply not have the information at hand yet. For that reason, POPIA uses wording that you should notify as soon as reasonably possible after the breach. This is specifically done to allow you the time to investigate and determine the scope of the compromise. It also then allows you time to restore the integrity of your information systems and to account for the legitimate needs of law enforcement. Over and above regulatory notification in terms of POPIA, it's also been our experience that you are likely to be better off being transparent and open with affected data parties. Ashley Madison made the mistake of keeping the data breach quiet for as long as they possibly could. And when it finally broke in the media, the executives and the board of the company were already viewed in a negative light. It all seemed to cement that they wanted to cover it all up at the grave expense of their customers. Rather, provide affected parties with feedback and information as soon as the experts appointed to deal with the breach confirms that it is safe and appropriate to do so. Lastly, you will have to take a stance on your thoughts and views around ransom demands. Many people indeed take the view that paying a ransom might be worthwhile. It sounds strange, but in effect and practically, a cyber criminal's greatest asset is its integrity. The fact that they won't release your information if you pay the ransom. Because if they don't do that, their entire business model collapses. No one will pay a ransom to a cyber criminal that is known to leak your information anyway. However, be that as it may, we would not advise or recommend paying a ransom demand. Essentially, by doing that, you are perpetuating the crime that you have just fallen victim of by providing the cyber criminals with the incentive they need to keep on terrorizing commerce and society. Ethically, in my view, that can never be justifiable. Now, coming to our final thoughts on the matter, unfortunately, cyber crimes are indeed here to stay. Incidents are almost commonplace now. And it's not a question of it's not a question of if a breach will occur. It's a question of when. The South African regulator is indeed functioning well. But as we said, monitoring your own POPIA compliance and taking that to heart will only be to your benefit and mitigate your risk in the event of a breach. And then lastly, don't just talk about data privacy and cybersecurity. Live it every day. Employ it in your systems. Make it part of operating your business. Your customers, clients, and employees and stakeholders really do expect it from you. And with that, ladies and gentlemen, our half hour is more or less up. Thank you, and I hope you have a wonderful Friday and a fantastic weekend ahead.